If you're like a lot of small businesses, you're probably wondering right now if you can still use non-compete agreements. If you're not aware of this, the FTC proposed a rule in January that would ban non-compete, non-competition, non-compete clauses, non-compete agreements, all those terms that you hear around non-competition. They're all basically the same thing. And the FTC has proposed a rule banning them, but is still accepting comments. So if you have an opinion on this and you want to make sure the FTC considers it, I recommend that you go to ftc.gov and submit your comments before April 19th, 2023. I'm Nancy Schick of 30R Conflict Resolution, where we take a holistic approach to workplace dispute resolution, and non-competition agreements, believe it or not, will end up sometimes as the subject of those disputes. So why are they used in the first place? That's the number one question you want to ask. Do you need it? Depends on what you want to do with it. If you're trying to limit a high level employee, a key employee who has a lot of confidential information that they could use to open a competing business and possibly put you out of business, that is where we usually use them. But if it's someone in a restaurant or a retail store, they might not have enough information or access to that kind of process that where they could open a separate business and compete with you. So it might not even make sense for all of your employees to sign it. Second, you want to look at why we are even discussing a potential ban. And that is the public policy of the government doesn't want you to restrict people from getting gainful employment if they leave you. Now, again, having them start a separate business, whether it be on their own or going to work with another one, using your trade secrets and some of your confidential information, that's a different story. But that also falls under other restrictive covenants. So we might not necessarily need a non-compete agreement. You might be able to cover the reasons for restricting any of that information in a separate agreement. So don't worry so much about it, maybe. So what do you do now? You want to identify what needs protection, who has access to it, why they have access to it, and the potential harm that they could cause. Then you want to narrowly tailor any restrictive covenants that you write and have your employees sign. Those will sometimes pass muster, even if they go to court. So if you're not sure if your restrictive covenants, that again, it includes your severance agreements, your waivers that come within those severance agreements, as well as your non-compete, confidentiality, non-disclosure. Click that button below, request a consultation. And in the meantime, keep listening with your third ear for those hurts you can heal.